this. And good morning and welcome to our session on consent and Bill 64. We are the Response Marketing Association, and my name is Derek Lackey. I am the chairman of the Response Marketing Association, but I'm also the managing director of Newport Thompson. The Response Marketing Association exists to help marketers be better marketers. And one of the things we've seen over the last 10 years is privacy is coming on like a freight train. And what we're beginning to see in Canada after now 3 years of or 4 years of seeing it in the EU, we're starting to see the data protection regulations be upgraded and implemented here in Canada. And it began as it did in the 90s with Quebec. Quebec threw the first volley out, which forced PIPEDA to come into existence by the feds. And they once again lead the way by passing Bill 64 in September last year. And the first parts come into effect this September. We'll talk more about that. But for now, I'd like to introduce my panelists, Abigail Dubanecki and Konstantin Karbolaitis. So I pronounce it right, Konstantin?
Yeah, close.
Close?
Close to mine too. That's okay.
Yeah, we're not too picky.
Right.
Actually, let's have Abigail introduce yourself. And get the pronunciation of your name right. I apologize.
Okay. Hi, I'm Abigail Dubanecki, and I'm a privacy lawyer and privacy professional who teaches, trains, consults, advises. I like the product placement there. Is that a response marketing association thing? Do we all have to have our product placement?
That's right. Yeah.
Yeah. So I live and breathe privacy and data protection. I'm super interested in all of these things. I have a transatlantic practice advising UK and Canadian clients. It's been primarily GDPR, but now has been a lot of Bill 64 as well. So very immersed in this area. I'm licensed in Quebec and Ontario and bilingual, so that helps. And right now I'm based in traditional unceded territory of the Algonquin Anishinaabe people, otherwise known as Ottawa.
Thank you.
Fantastic. And my name is Konstantin Karbolaitis. I am called only in one jurisdiction, Ontario. But I have been involved in international data privacy for about 18 years. I was responsible for Symantec's Global Privacy Program. I was Chief Privacy Officer at Mercer. I've fulfilled a number of different roles. I'm with Innovation, which is a boutique privacy law firm here in Canada. My clients include Canadian as well as non-Canadian businesses. And so, my involvement in privacy has been multifarious and engaged with lots of different kind of marketing organizations within companies and with clients. So I'm hopefully going to bring a perspective in addition to Abigail's that is comparative with what is happening elsewhere in the world and also, from a Canadian perspective.
Great, thank you. So, at the top here, Bill 64 really affected 21 different acts in Quebec, but the two that we're predominantly concerned about in this context is the PPI-PS, which is the public sector law for personal information, and the public body law as well. But what we're going to really address today predominantly is PPI-PS, the public sector law.
Private sector.
You mean the private sector?
Sorry, private sector law.
Yeah.
Only because, yeah, the public body one addresses a great deal of access to information as well as the points we're going to talk about today. The public sector law doesn't focus as much on that. So, let's start off with, we have heard from several sources that it's tougher than the GDPR. And, Abigail, maybe you could start with this. I get the sense that one of the tougher areas is consent. So, and by that I mean the GDPR. About 90 to 95% of the business done in the EU is done under legitimate interest. The lawful basis of processing is claimed as a legitimate interest, and then Quebec left that out. So Quebec only has consent and contractual, and consent's got a few exceptions, but there's not a ton. Like, it's not like Bill C-11 where there were 33 different exemptions that you could literally carry. Facebook could carry on doing everything they're doing today under Bill C-11. Quebec went much tighter than that, and I wonder if that's one of the areas that's tougher than the GDPR.
Yeah, I mean, before we launch into that, I'll just caveat that by saying I don't agree that C-11 was quite as wide on the exceptions as to let Facebook do everything it does, because there were a lot of other compensating factors in it. But that said, there is this extremely frustrating tendency in Canadian law to stick to consent and then create a number of ridiculous and unmanageable exceptions to consent. There are actually many exceptions to consent under I'm just going to say Bill 64. So the way it amends PIPs. So the resulting law after Bill 64 still has a ton of exceptions. What it's done is it's built in a lot of back-end controls to it. And so in a lot of ways, if you were to do the mapping between the 6 lawful bases that you have under GDPR and what we do in Canadian law with our different exceptions, you could roughly map that. And in fact, we kind of did in our latest submission to Ontario for My Data Canada. And I can share that with you separately in a link. But I think as a starting point, what's top of mind probably for a lot of our listeners would be, does this law even apply to me, especially if I don't have a business in Quebec? And I was thinking maybe if we could just kick off with that, and then I can highlight some of the new things brought in, and then some of how that fits in with the old, and then talk about the GDP, like sort of how that matches up with GDPR.
Yeah, great.
That sound fair?
Yeah, as from my perspective as a privacy consultant, I believe it applies to all businesses, just as California applies to marketing in the US.
It applies to enterprises, which is broadly defined, and so nothing has changed in relation to that.
Yeah.
And the sort of general law with what is an enterprise operating in Quebec, that's not been altered.
It's actually not operating in Quebec either. Yeah. So like there is no qualification.
That is the point I was about to make. Given that 22.5% of the population is Quebec-based in Canada, you're not going to have a national database without 20 to 25% of that database being Quebec residents. Therefore, Bill 64 applies. Is that a fair statement, Abigail?
It's not as simple as that. So why don't I explain sort of the mechanism by which it would apply? Okay. And then Constantine, I think, has some really good insights into practically speaking how it's going to get you either way. Right. So leaving aside the technical piece, it's going to affect you either way. So the way it works so because we're talking about the private sector law, as Constantine mentioned, it applies to an enterprise. Now, enterprise that's collecting, using, retaining, or sharing personal information as it's defined under Bill 64 or under PIPs as modified by Bill 64. First of all, the definition of personal information is much broader, and I'll get to that in a second, but we've already broadened the scope. So an enterprise is basically, it's an organized economic activity with a commercial purpose. That affects a lot of things, right? So Clearview AI tried to pretend that it wasn't doing anything that was associated with Quebec because its servers were outside of Quebec, because even though it may have captured, they tried to downplay how many Quebec faces were captured in their database of faces that they scraped, but they were specifically trying to sell to police authorities here in Quebec and in other parts of Canada. So that whole enterprise threshold is very low, right? So it's an organized economic activity for a commercial purpose or with a commercial dimension to it. You've got to look at the activity as well, not just the entity, right? So it will apply to the extent that you're engaging in that commercial activity. But the way we determine where the nexus to Quebec is the way we do in all aspects of civil law in Canada. So when we talk about even copyright or any number of different areas, even tort law, is there a real and substantial connection to the people of Quebec? And that's a test that's been done time and time again. We've got all of that, the factors that you need to consider. But for the purposes of our audience that isn't necessarily interested in doing a 5-part test, and et cetera, the simple way that I say it is, if people in Quebec are going to be impacted by it, and I don't just mean that you're collecting their personal information, but if they are impacted by what you're doing and their privacy interests are engaged, so beyond personal information collection, are you surveilling them? Are you using their image for certain purposes? Are you doing certain things along those lines? Then it's likely going to be applicable to you in some way. Now, especially as a lawyer operating in the space, drafting loads and loads, chances are it's going to affect you somehow. So how is it affecting people outside Quebec?
In the same way that Canadian companies have found themselves having to negotiate data protection addendums with companies that are in the US and the EU, they are going to be caught by contract. If you want to close the deal, you're going to be signing something. Mm-hmm. And what your client organization is going to be doing is making sure you don't get them in trouble. So they're going to be passing many obligations down to you via contract. Canadian companies particularly are going to be, have been in sort of the line of, well, we've never had to do standard contractual clause agreements before, but then many Canadian companies use cloud services based in the US. So they're being incorporated now into that sort of whole economy that's now built up around doing not just data protection addendums, but being caught up now in the whole assessment of the risk of transfer. So now looking at what are the legal risks associated with the data? And what Quebec has done, well, minus legitimate interest, is bring GDPR to Canada. And so now if you're anywhere in the supply chain downstream from a company doing business in Quebec with Quebec residents, processing personal information of Quebecers, you are going to get that passed down to you. And in two ways. One, they're going to be asking you to do a privacy impact assessment around technology. Secondly, whenever a company doing an enterprise, processing personal information in Quebec transfers data outside of Quebec, it explicitly requires a transfer impact assessment. So there's 2 points at which organizations are going to have to present information about how they're protecting and safeguarding data. And also, those are going to work their way into the contractual obligations you now are undertaking. And this will be necessary in order to satisfy your clients' need to stay out of trouble, because they are obliged, they are accountable for what happens downstream with their third parties. And again, nothing new or surprising in that. It's just, again, if you've managed to escape this, in terms of, the impacts of GDPR or, CCPA in California, you're not going to avoid it now. Because as Derek's pointed out, the numbers are likely in favor of you're going to be having to deal with this.
Yeah, and I would take that, bring that back to this notion that Derek kicked off with, which was consent versus legitimate interest. And actually, I would once again challenge you on the notion that there aren't that many exceptions. In the exceptions clause, there's even just one that has 14 exceptions alone, and then there's so many others. 2 points that you have to make very clear when we're talking about the Canadian context, and in particular Quebec, is we have different lawful bases, if you want to call it that, for the different parts of the life cycle. So collection is one thing, right? Consent to collect doesn't necessarily give you consent to use in other ways or to share onwards, right? So there's use, there's collection, use. For Quebec, there's also retention or holding. And disclosure. And then Quebec also, in some provisions, also considers destruction, right? So the PIA requirement includes even if you're acquiring or overhauling a technology used for the destruction of personal information. So it really goes far. So getting back to Constantine's point, one of the exceptions to consent is to share with a service provider, which is a huge sigh of relief, because that was a really problematic thing. I have to share with my service provider. They can't provide the service, and nobody does this stuff all by themselves. We all have a whole network, an ecosystem of service providers, especially in the software as a service world, that we rely on. So it's just not feasible. That said, you have to have a contract with very specific terms that need to be included in there in order for that sharing to happen. So every time you have an exception to consent, what we're doing is we're beefing up the safeguards on the back end. So what you really need to be your guiding light, apart from all of these like technical things you need to do, depending on which consent you're relying on, is, are they getting consistent and adequate protection? Is the spirit of the law protecting them and making sure that their personal information isn't going to be used in ways that you didn't tell them it was going to be used, shared with people that they would be surprised or shocked or annoyed that you're sharing it with, or held on to for much longer than necessary, presenting all kinds of risks, or sent to other jurisdictions where they're not going to have the same rights. Like, think of it in a human kind of way, and that will help you guide your approach.
And it's also important, like in the international level with the Schrems II decision of the European Court of Justice, a contract by itself is not sufficient. You are going to have to show what is a PIA or transfer impact assessment meant to show? That you actually have controls, that you actually are safeguarding the data. This is not simply a paper exercise for lawyers. It means interacting with IT and information security to actually make sure that you are living up to the commitments that you're making in the contract, because now that obligation is on companies in Quebec, directly subject to this law, to make sure that that's happening. They're accountable for that.
It's connected to the privacy policy.
Exactly.
I've seen hundreds of privacy policies that no company actually follows.
Well,
yeah,
they just
literally another issue in
yeah.
Canada.
Yep.
When we actually just reiterate the 10 principles of CITA and call that a policy. That makes my brain hurt. The other thing that's important, I'm glad you mentioned policy and notice, because to picking up on Abigail's point about third parties, while consent is not required, you have to identify them. You have to
tell them
actually, that's part of the clear and express consent, which
so if I'm
is by itself a challenge, because many organizations don't actually understand their own flows of data. So how can you actually get clear and informed consent when you don't even know sometimes who you're sharing it with?
Especially if you're participating in real-time bidding and programmatic advertising, which the IAB Europe decision, the Belgian decision, made very, very clear, and which people working in that space have talked about a lot, the opacity of real-time bidding. I feel like we're getting ahead of ourselves. So, can we maybe take a step back?
Yeah.
The point about the contracts, though, is true. Even if you're in Quebec and you're a service provider, you have to have those contractual provisions. But the minute you're outside, the Quebec-based entity or the entity that is transferring personal information from Quebec to another place, and that includes Ontario, right? It doesn't have to only be, they have to do a specialized PIA and have a contract in place. So there's the PIA is basically a transfer risk assessment. So that part is true. And then you've got to enshrine the safeguards. That all becomes binding. So we can rehash our DPAs from GDPR. A lot of that stuff will be very, very helpful, but it's not exactly identical.
So as a practice, marketers really have to pay attention to
the contracts that they're signing with whomever it is that they're using, whether it's for analytics or research. You've got to look at that now with a new lens. Does this comply? Have I communicated adequately to the individuals? Because we got to get back to this whole, how do we get consent thing? Because this is actually very important. And that's that part of that communication, that transparency obligation, which is very much, and Abigail, you want to talk about this, very much raised, I think, the bar in terms of what needs to be communicated in order for that consent to be effective.
Yeah, so definitely. So can I just to situate the audience, I just want to highlight, there's a whole raft of new changes that came in. Beefing up of transparency and consent is going to be a really, really big one, because without that, you can't do what it is you want to do. But before you even ask anyone for consent to do something, you have to actually have a serious and legitimate purpose to even be collecting the personal information, whether you're collecting it directly from them or from a third party. And collection from a third party is allowed, provided all of the appropriate conditions are met, right? So they need to know that someone is collecting it on your behalf, or that they're going to be communicating it to you, right? So even when you're sourcing data, you need to ask yourself, has this been legally sourced, or am I getting into a situation where I can get into trouble? On the notice and consent, if we start with this whole notion of consent and the situations where consent is required, it has to be manifest right? So they have to actually make it clear that they are really giving their consent. So bundling together a bunch of, things and then sort of saying you agree to our privacy policy is not going to work. Just like with the GDPR, it's specific and granular. You have to tell people what it is that you're actually doing. So you can't just say that you are, collecting it for some vague purposes. It has to be specific, which means you have to have thought of what your serious and legitimate purpose is. Now, a serious and legitimate purpose is a really important, like asking yourself why in the beginning and being able to have a defensible position is going to be critical to you being able to get that proper consent later on. Because if you haven't thought it through, you're not going to be able to be specific enough, and then the consent you have is going to be invalid. So what is a serious purpose? Well, what Quebec law does is it kind of bundles in a lot of other things by asking really about how necessary is it and how proportionate is it to the end goal that you're trying to achieve, right? So if you could find an alternative way to collecting all of this personal information or to undertaking this activity that could have privacy implications for someone, then choose that or find a more proportionate way. So that's part of the seriousness analysis. And of course, I'm being very high level here. The next piece is legitimate. And it's not legitimate if it's unlawfully obtained, first and foremost. So right then and there, that's going to have an impact for you. So Clearview AI got into trouble because they broke the law, even scraping the data, because there's special rules around biometrics here that they didn't even bother to follow. So if you are getting data from another party, so you've received it, let's say from like a data broker, or you've received it from a marketing analytics firm, but they didn't actually, do their due diligence and get the consent, it won't be legitimate and it won't be licit. So it has to be licitly obtained. So first of all, you've got to have a purpose, and then what you're collecting has to be necessary for that purpose. And then you have to limit your use to that purpose. So once we've done all of that homework, we have to tell people what we're doing, right? So we have to, and then in order to get consent, it needs to be informed. And so getting back to consent, I'm sorry I went a little bit backwards. So getting back to the conditions for consent, it's got to be manifest. It has to be specific and granular. In some cases, it's allowed to be implied, not always. There's certain situations where it's actually explicit consent is required. I'll get to that in a bit, but it has to be informed. And that's where you're really going to fall down if you're sloppy or you're copy pasting somebody else's privacy notice or just regurgitating the 10 principles. If people don't really know what you're going to do with their personal information, you cannot say that they've consented. And that includes the third parties that you plan on sharing it with. So again, and getting back to the RTB situation, it's really, really hard to say you've gotten consent to share it when you don't even know who you're sharing with, right? And then it has to be freely given and unconditional. So that's like GDPR as well. So you can't bundle it in with other things. If it's not necessary for the purpose of the initial service they're signing up for. So for example, they've signed up to, they've downloaded your app that tells them how to get from A to B, a navigation app. That doesn't automatically mean that consenting to what you need for the navigation purposes allows you to do analytics on their data.
Or maybe even more simple example, if I'm selling you a bed, it's implied I need your address to deliver the bed. Mm-hmm. And if I ask now, I want to send you marketing materials about bedding supplies, that doesn't imply that I can send you all sorts of other stuff, right? So the further away you get from that original purpose, the more explicit you have to be about getting the consent. I don't think that that's new or surprising. I think that's still, I always has been, a good guidance. And now there were two questions I just want to make sure we touch on. Legitimate interest is a much broader concept under European law than the legitimate providing
serious and legitimate purpose.
Serious legitimate purpose. And where the quote's quoted, where the use of the information is necessary for the provision or delivery. I think that qualifies it very narrowly. It's so I can deliver you the bed. And legitimate interests under GDPR is a much broader concept. It's a legitimate interest of the business. Mm-hmm. And as Derek pointed out, and as the regulators in fact have said, consent should be the last basis under GDPR that you would rely on. Legitimate interests or some other basis is typically where you want to go to first. So this is not the equivalent to the legitimate interest exception under GDPR. Having said that, Abigail has pointed out that there are a number of exceptions which approximate that in the crazy way that we've approached.
Yeah, and I would just say, so, and I don't want to, because I don't know that our audience necessarily knows the three-part test to legitimate interest, but what I want to make important this is about why am I collecting this in the first place? What's my purpose? It's not about whether I can or not in terms of consent. So you have to have a purpose, and that purpose has to be serious and legitimate. Right. But there's a fifth point too to consent. So I mentioned the 4 qualities of consent. There's a fifth one as well, is that it has to be time limited. So as soon as the use, that original purpose, so the purpose is to deliver the bed. Now, you may have another reason by law for tax purposes, for example, because you could be audited or whatever, that you still need to maintain some of that customer information and the delivery and so on and so forth. But whatever you can't justify retaining because of that original purpose or some other constraining purpose that you have, like a legal obligation, you have to delete that, right? So there's some very strict data retention obligations under GDPR. So what does that mean for transparency though? So that's getting consent. The third condition I mentioned for getting valid consent was that it's informed. And that's where we see this interconnectivity between transparency, so what you tell people, notice, and whether or not their consent is valid. So on transparency, you have to tell them a number of things. Do you want me to list the things now, or?
Yeah, just a context for this. So I'd love to know those things, but so no longer can you go into a retail store and they say, we want your email address so we can send you a receipt, and then you're added to their promotion list. That's a practice. It's got to stop.
Yeah.
Right?
And there's a causal dimension as well. I don't know if one of you wants to touch on that first, and then I'll talk about the notice requirement.
No, you go ahead and talk about notice requirement first.
Oh, okay. So on notice, there's certain things you have to tell people at the time of collection. And then there are other things you have to be prepared to tell them after the fact if they ask, right? So there's a lot of stuff you need to know to fulfill your transparency obligations. One of them is that at the time of collection, you have to tell them why and how you're collecting it, right? So, and I'll get to there's another piece specific to like websites and technology as well that we have to talk about, but why and how you're collecting it. If you're getting it from another source, be prepared to tell them what that third-party source is if they ask. So if you're not getting it directly from them. If you're using technologies that enable profiling, geolocation, or identification of individuals, so we often have this with like cookies and trackers on websites or in mobile devices or IoT, anything that, or beacons in stores. So we're seeing it increasingly in the physical environment. There are ways to profile people, identify them, or locate them. You have to tell them that you're using this technology, and importantly, how they can enable it, which by implication means it can't be on by default. I'll get to that, back to that in a second, because I'm sure a lot of people will have a ton of questions around that. And then where applicable, if there are third parties involved in the collection of it, you need to tell them who they are or the categories of third parties. The categories of third parties that will receive or have access to it, and that includes within your business. So would this be the marketing team that would have access to it? You don't have to say Constantine has access to it, but you have to say, our legal team will have access to it, for this purpose. So you're really getting into your record of processing activities under GDPR, right? Like, be prepared to answer all that stuff. And also whether it's being shared outside of Quebec. That's a really, really critical piece you need to tell people. If you fail to tell people these things, then it's going to be really tricky for you to do them. On the flip side, if you have delivered that content that you need to deliver, and you've delivered in a clear and concise manner, which is the other important piece. It can't be
in French. It's got to be very clear.
And in French, yeah. if you're in Quebec, yeah, and in French, there are French language charter issues that apply as well. So make sure you get a really good translation. Constantine and I can recommend some people for you if you need them, but really good translation of it. And the person gives their personal information to you anyway, then they can be said to have consented to it, except for those situations where explicit consent is required. So biometrics require explicit consent. They've beefed up the biometrics. So biometrics is where you use, characteristics of someone's body, their voice, their face, their fingerprints, breathing patterns, heart rate, all of those sorts of things, biometrics. That requires explicit consent and prior notification to the Commission, the Data Protection Authority, let's just say the CAI to make it easier. And if you're creating a database of it, there's a whole other host of things, including a 60-day prior notice requirement to the CAI. So there's a lot of stuff you have to do in that context. The other piece is if you are a lending or a credit, you're making decisions related to credit worthiness or lending. So I see we do have some financial institutions on here. There's the Bill 64 changes, but there were other changes that also came in through another law that came into force as of February of last year, which really beef up the transparency requirements there and the access and rectification rights that people who are applying for financing or credit or loans or whatever have. And so I won't go into all of that detail now, perhaps unless people ask, but suffice it to say, no more of this. Constantine's applying for a loan and he doesn't realize that you've gotten a bunch of stuff from Equifax and I don't know how to correct the record and Equifax has it wrong. That day is gone. If you've used it to increase or decrease my loan or reject me or accept me, I have a right to know and I have a right to challenge that. The other piece is automated decision making. So you need to let people know that you are going to be making a decision that is an automated decision, no later than when you inform them of the decision. So I'm not going to hire Constantine. The computer said no, and I'm not going to hire him. So I need to tell him not only that I made that automated decision and that a computer was involved in saying no, or that it was the computer that said no, but here's the personal information that was used. These are the reasons that led to it. And you have a right, by the way, to have this, the underlying personal information corrected or to challenge the decision internally here with us by somebody who has the power to change it. So you can go over my head, my boss, who actually has the power to change, a human can change the decision. So there's a lot on transparency, and then also you have to publish your policies and things like that on your website too. And I mean internal governance policies. So just on transparency and consent, there's a lot, but that's just a small part of it.
There's a lot packed in that. And, it should be noted as well. I mean, I responded to a question. Yes, it means disclosure outside of Quebec, not just Canada. And CASL, we'll go back to Derek now, still does apply. There are concurrent laws that apply, with, provincial and federal level. So you're still going to have to pay attention to CASL.
Absolutely. Absolutely.
And can I add one more point on that too? Another exception to use is consistent use, right? So exception to consent. So if you want to use someone's personal information for a use that's consistent with the original purpose, and there really does have to be a proper link that someone would reasonably expect, you don't have to go back and get their consent again, right? So to use your address to deliver the furniture is a really obvious one. They have explicitly carved out any kind of prospecting, even if it's for charitable purposes, from that consistent use. That one, you're going to have to get a brand new consent for that. Right. So even under PIPs, that's a requirement.
And back to my earlier example of getting your email collected at the cash register at a retail store in order to send you a receipt, it's not reasonable to expect to be added to your promotion list when I give you my email address, right? Right. So that wouldn't meet any of the consent requirements under Bill 64.
Or for you to bundle it and sell it.
Right, exactly. Or develop a profile about it. Right. The other thing about CASL is, remember, though business contact information has been accepted, CASL still applies. So it's not like, a free for all. Now that you've got this exception, you still have to pay attention to CASL.
So have we clarified what that is? So
can we do that in the context of personal information in general? Because I think that's another, so we started out by saying, why should you care, especially if you're not in Quebec? And we made it very clear, it's going to hit you and bite you somehow, so you have to care. The second piece is, well, when should I care? And that is if I'm using personal information, collecting, using, et cetera, personal information of people in Quebec. Well, so personal information is defined much more broadly now because it includes de-identified information as well. So indirectly identifiable. So that broadens things very, very broadly. They have carved out, though, business information, but really it's not as broad as it sounds. It's effectively, like if you were to talk about it in more practical terms, it's effectively business contact information, or the information you would need to be able to engage with that person for, within their context of their function. So their title, the company name, et cetera, et cetera. Now, what does that mean in terms of, like, if we're not calling that personal information, well, what does that mean then for the rest of the obligations? Because if it only applies to personal information, and now we're not calling that personal information, does it apply to all of these other things? I think in practical terms, you should assume if you're going outside of that narrow, I'm just trying to contact you in the context of your role, you should be very circumspect about assuming it doesn't apply to that information for other purposes or other types of uses.
A really good example is what tends to pollute, customer relationship management systems is I've got a business contact. This is their spouse's name. They've got 2 kids. They like whiskey as opposed to wine. Now you've drifted outside, frankly, of the business contact information exception.
And their function as well.
Yeah. And now you've got personal information.
And your profiling.
And your profiling potentially. So, you could be stepping outside of it very easily, even if you think what you're doing is a B2B kind of communication. But, again, CASL still applies even to B2B communication. So you don't, again, get a holiday from that. And you do need to think very carefully about the mechanisms by which, again, you're gathering that information to ensure it's legitimate and appropriate.
In practical terms, and I pose this to both of you, in practical terms, does this is this the beginning? Because Quebec's only the first. Ontario's coming, the PIPEDA's going to be updated, and it's all going to be relatively in the same pocket. So is this really forcing marketers to look at Abigail, you referred to the customer life cycle. A lot of marketers use personal data and data marketing to bring new clients into the fold. So it's lead gen,
lead generation, not just direct marketing.
It's cold calling, right? It's like, you don't know me, but here's what I do, kind of communication. And a lot of marketers use it extensively that way. Are these laws going to force us to use more traditional forms of advertising and promotion and rely a little less on personal data?
It depends on how important that is to you and how much you want to think about it, because we've only scratched the surface of all of the things that this requires in terms of personal information. So the extent to which you're relying on personal information to accomplish your marketing goals, the greater your reliance on personal information, even de-identified. And I do want to take a minute to talk about that. If it's reasonably re-identifiable, it still falls within the purview of the law. And so even a lot of the stuff we try to do with analytics would fall within the purview of the law unless it's irreversibly de-identified. So we've got a really broad scope there. So the more you rely on personal information, given that broad definition, the greater your compliance burden. And here's why. I started out by talking about, first of all, you got to have a serious and legitimate purpose. Then you're only using what's necessary to accomplish that purpose. Then you're only restricting yourself to that purpose. You're limited on sharing. You're adhering to all the fair privacy principles. You're doing your PIA when you acquire technology. You're doing your transfer risk.
You delete it when you're done.
A lot of money to Constantine and myself to help you, and you have to have a comprehensive privacy program. So I think what's happening to a lot of marketers is they were allowed to do so much in the background before. A lot of shady data brokers who didn't have direct interaction, who weren't consumer facing, felt like they could get away with a lot of stuff. And now what we've done is we've really tightened up the sort of network effects, where there are all these choke points where you might not be directly consumer facing, but you have lots and lots of data and you're engaging in very high risk activity like profiling and targeting, that all the way down the chain now we have to clean it up. So what does that mean for marketers? Well, you have to ask yourself, am I really getting the value from this hyper targeted based on 20 things that I know about Constantine and the watch he's wearing, and whether that's even accurate anymore, because maybe that was an old picture. Am I really getting value out of it as opposed to some other approach that's maybe a privacy preserving, edge-based, example of like in-browser targeting where I don't get the data, there's just a match and my ad gets pushed to them, let's say through a notification on the Brave browser, or contextual advertising. There are a whole host of them. And I did read an article, which I think we can share with the audience after, on privacy preserving, privacy first digital marketing strategies. This is a business decision you have to make as marketers, because you can look at it as a compliance burden. There is a lot to do, as I mentioned. At the same time, there's a lot of benefit. Like a lot of the things that you have to do in cleaning up your data supply chain is actually going to help you avoid things like ad fraud, which is rampant in a network of opaque. You're going to save a lot of money because there are a lot of people just lining their pockets. And so if you're a publisher, you're getting pennies if pennies don't even exist anymore in Canada, but pennies on the dollar for your ads.
Yeah.
They're stealing your audiences. There's brand safety issues. I mean, there's a whole host of issues. So cleaning up your data supply chain and using personal information really strategically can be a huge advantage to you. And even on the analytics side, like you're still going to have to do the PIAs and everything else, but you're going to be doing things intentionally, and you'll probably get much, much better data. So maybe less of it, but much more strategic and effective use of it. So that's the carrot to getting this stuff right.
And that's really what's happened with Castle, right? We've got smaller lists, but they're more engaged, and they're right.
They did a big cleanup job.
Yeah.
And actually, to the whole cleanup, there was a question about timing. If data has been collected in the past, how do you deal with that going forward? My suggested answer, Abigail, you tell me if you think I'm wrong. You may have gotten, consent at the time for the collection of it. But for going forward, as you pointed out, it's not just at the point of collection, it's also the use, the disclosure, the retention that you now have to comply with, even with your existing data sets.
And there are very strict penalties for holding on to data for too long. Oh, and by the way, getting back to that whole serious and legitimate test, we're going to have to be really comfortable with that, because even to anonymize now, so the default position is once the purpose for which you've collected the personal information has expired, you no longer have a justification for retaining it, and you must destroy it. And there are very significant penalties for not destroying it. They're not joking around, because data breaches are a dime a dozen these days, and all these data lakes that have been sitting around and we don't even know what data we have is spilling out into the dark web. And so they're very serious about data retention.
And so absolutely point out the significance of the fines is very much higher, in that if you are caught by this law, your potential fine range is 4% of global revenue, or 10 million, I think, Canadian.
Well, so you have a 2% category and you have a 4% category, depending on which ones, but data retention.
Administrative versus penal, right? So this is meant to get people's attention. There's consequences.
Penal will go up to 25 million, won't it?
Yes.
Yeah.
And there are aggravating factors as well. And so if you've already gotten into trouble in the past, that's an aggravating factor, and the courts are allowed to consider. And there are punitive damages. They're in personal litigation, punitive damages. You can see how that, that can go as well. But I want to get back to the anonymization piece, because this is really important for marketers. So there are two things: marketers or anyone doing data-driven analytics. Well, obviously analytics are data-driven marketing or business development. There are two things you need to think about. One is, let's say you're trying to repurpose your data internally. It has to be de-identified and maintained in a de-identified way such that you reduce the risk of re-identification. So even your marketing team, they want to do a trends analysis on who's actually buying this furniture and what the demographics are. They should not be able to say that Constantine bought that bed. Right? It should not be knowable for them. The minute you've failed on the safeguards internally, even within your business, to prevent us from knowing that Constantine bought that bed, or Constantine has a tendency to buy beds, or is even one of our customers, then you run into trouble because you haven't shared it internally properly. So that exception to consent has now been invalidated, and you don't have valid consent. So that's one control on the de-identification side. Obviously, as a business, you still need to do business with Constantine, so you can't completely irreversibly anonymize the data because you want to keep him as a customer. On the anonymization side, he's not a customer anymore. Sorry, Constantine, does this bother you that I keep bringing
okay, don't worry. I don't
You're
buy
the focus.
Stuff, but...
Derek is also a customer, but Derek, he's stormed out. He doesn't want to do business with us anymore. That's fine. We want to anonymize the data just in case, because he's an ex-customer and he used to buy some from us 10 years ago. Just because or just in case is not a good enough reason. The default rule is you delete it, you destroy it, unless you have a serious and legitimate reason to keep it. So if you're saying, I want to anonymize my old customer database for security reasons or for other purposes, well, then you need to have a serious and legitimate purpose. For example, we're going to do a trends analysis over 20 years. How is our business? If you can't articulate the business case, you can't keep it, not even in an anonymized form. And if you have it in an anonymized form, you have to have controls in place. We're in a dynamic environment here that you are continually reassessing re-identification risks so that you prevent it from becoming personal information again, and regulations will be coming out on that.
One good
excellent.
thing I was going to say is that the burden for de-identification doesn't seem to be as high as under GDPR, which is almost unattainable. So that does.
No, I would disagree with you on that.
Okay.
Pseudonymization would be the equivalent to de-identification. GDPR pseudonymization would be the equivalent to de-identification.
Okay.
Under anonymization under Quebec would be equivalent to anonymization under GDPR,
Okay.
except they define it
Okay.
explicitly. Sorry, I just had to
That's
Yeah.
okay.
spend a lot of time thinking about it.
Good point, important point.
With 15 minutes left, I'd really like to, there's a few questions. So actually, Alexander Blanc made a comment that Bill 64 is now Law 25, it seems, and quite confusing too.
I
Can
think
you-
Okay, yeah, I hate that. Can I explain that?
Yeah,
So
yeah, please.
just call it Bill 64 or call it PIPs as amended.
Yeah.
This is my own personal beef. Every year I don't know if we want to spend a lot of time on this. The way it works is something is a bill and then it becomes a law. When it's a law, it's officially published in the Gazette, and we have the Loi annuelle. It's the annual Gazette that publishes it. So it's 2021 chapter 25 is Bill 64, which has been adopted and it's final. So you can call Law 25, everyone is. If that works for you, fine. I find that really unhelpful. I would just say Bill 64 or PIPs as
Especially
amended.
since both Bill 64 and Law 25 amended other acts.
Yeah,
I think
it's
it's
just
much
not
more
helpful.
helpful to refer to PPIPs or PIPs as the
Or
law.
loi sur le privé. if
Yeah,
you're
the
talking
law, the law affecting private, companies.
private sector privacy law. Yeah.
Yeah,
But
there's-
here's a thing that all of these new data protection privacy laws are forcing. None of us have, few of us have really good processes in place to actually collect, track, and record consent. And we're going to have to figure that out. So
yeah, because it's all got to be provable. You've got to be
Yeah,
able to stand up and defend.
and that is my point, Constantine.
Yeah.
It's not good enough to have consent. You have to prove it.
Mhm.
So having some process in place that allows you to prove the consent when you're challenged by CHI or any other data protection authority around the world, you should be able to come forth with that. And most of us don't have a process for that. And I think that that's something that's hugely missing in the marketing community is preference management, automated preference management, for lack of another term,
And
that
can I
allows you to be able to prove it.
And I want to talk about the business case for that, because it's very easy to get caught up in the technicalities and, oh, well, technically, CCPA doesn't apply to me because I don't have a high enough turnover. Consumers don't care about those technicalities.
Right.
They have expectations now, and their expectations exceed the law. The law is always playing catch up. So the question is, what kind of conversation do you want to be having with your customer or your prospect? Do you want to have well, technically under Law 25, which sometimes people call Bill 64, no. The customer's not happy.
Yes.
You want this person to like you. So do things that, and what this is a real advantage by being upfront. You can leverage privacy as a, I know people say this all the time, but it is a brand differentiator. People appreciate it. There are tons of studies that have come out about it. They're finding all kinds of workarounds, to get away from being tracked when they don't want to. You have the data from Apple, and they're asked to track and what the opt-in rate is. People don't like it. And then you've got TikTok videos about how creepy their algorithm is, that they're not even, they're targeting me with stuff that is not even about stuff that I talked about. So now their algorithm really knows me. They don't like being hyper targeted. They find it really creepy. They like context.
And
Because they're like,
and that is beautiful. The whole purpose of data protection laws is that we've not done a very good job as a business community in the last 20 years at respecting people's privacy and it's we've taken the position that when we collect the data, it's ours, and we've realized the last 5 to 10 years like that is like not the
That-
case at all. It still belongs to the individual, right?
Because it's about
regardless-
the individual,
Right.
right?
And
It's about them.
regardless of the law, I mean, one of the things that GDPR did do for the planet was change people's awareness of the issues. So many Canadian privacy officers noted over the last several years a sharp increase in the number of access requests. Now, our law
Yes.
didn't change. We always had those
We already
rights.
had it.
But GDPR made people aware of it, right? When all of us in 2018 got these emails saying, can we continue to use your information? It was like spamming the planet. And so everyone now has these expectations. If you're not thinking more broadly about, if all you're doing is trying to meet the bare minimum, first of all, you're going to be behind the 8 ball at a certain point because the line keeps moving. Second, there are more and more states in the US who are enacting laws. We have probably, provincial changes happening. I think BC and Alberta are chomping at the bit to update their legislation. Ontario issued a white paper or consultation paper looking at their own private sector privacy law, looking more to Quebec than a model than the C11 at the time. We will finally get, I think this year, another draft of what would be a federal law. So changes are in the wind and they're going to impact you. Why not get ahead of it, strategically thinking about consumer expectations, as well as meeting these varying expectations, whether they come from Castle or other sources, and just doing the right thing with regards to your client base, because that's going to be now where you're going to be able to, as Abigail's pointed out, differentiate yourself competitively, but also you are not going to be aiming for a 51% passing grade. You don't have to be perfect, but you shouldn't be aiming for 51%. Like I said, 51% today is 49% tomorrow.
Mhm.
You really want to be in the comfortable range where your clients feel comfortable dealing with you and they're enabling you to use information, their data, because they trust you.
Well, that's another great point because we're really at a time in, by all research I've seen, including the Office of the Privacy Commissioner, that people don't trust business with their data. So consent is going to be difficult to get.
Yeah.
In a world where consent is going to be required. So
going back to your earlier point, advertising as an industry was quite successful before the advent of the internet.
yes,
And it will potentially mean coming back to some of those basic principles. And Abigail, I've talked about whether in fact what, all of this, buying and selling of data has actually, quantifiably, like companies are trusting or hoping that what they're doing is working, but not really certain of it.
Yeah. And can we talk about that? Because
Yeah.
again, remember when we talked about serious, so from a data protection or privacy perspective, we talked about serious and legitimate. Serious means necessary and proportionate. And if it's not actually achieving its goal and you can't bring the data to show that, then, that you need all of this data so you can target people with ads because that's what they want, then you're already going to fall down on the serious side. You're not going to meet that. And I put 2 things in the chat. Dr. Augustin Fu, who's an expert in ad fraud, absolutely please subscribe to his newsletter on LinkedIn. If you're in anything related to marketing, you are missing out and you're wasting money if you're not reading what he has. He does extensive analyses of where the data goes, and he's found so much ad fraud. He's also identified that actually right now contextual ad space is a lot cheaper to buy because people are still buying this notion that hyper-targeted advertising actually gets you better conversions, which no one's really been able to show the data to show that it does. And because of that, you're getting a lot more out of your ad spend if you're buying contextual. And you could do A/B testing right now, like before all of the different aspects of this law kick in. Let's do the A/B testing. And if you find actually the targeted really does perform better in terms of actual conversions or actual sales or something quantifiable, then maybe you have a case. Clean up the supply chain in the meantime. The other thing is brand safety. So Claire Atkins and Nandini Jami, who have a blog called Branded, and I put it in there, and they run the Check My Ads Institute. They do a lot of really in-depth analyses to see where people's ads are actually ending up. And by participating in, this very opaque network, there's a lot of opportunity for your ad spend to be misdirected and your ads to be placed on websites that are inconsistent with your values. So promoting hate or disinformation and things like that. So those are two things that you can do to clean up your data supply chain, save yourself some money, and actually achieve your goals. And it does tie in with data protection because all of those principles are still there. Can I say one last thing? I know I've been speaking a lot, but I want to disabuse people of this notion around, there's a lot of confusion around the whole cookies and privacy by default requirement and tracking, and what does that all mean under Bill 64? And part of that has to do with the fact that the legislators don't fully understand how cookies work, but they also had intentions. I listened to the debates hours and hours and hours, and I took extensive notes. So I know this stuff in my sleep. But the final version of it, there's something that slipped in that says, so on the one hand, you have to tell people if you're using technology that geolocates, identifies, or profiles them, and how to turn it on. So what that means is that it can't be on by default. So what does that mean? Well, we put cookies there for targeted advertising or any kind of profiling right away. You're going to have to get opt-in consent. Now, if you skip over to the confidentiality or privacy by default requirement, which is when you have a technology or information service that provides privacy preferences, they slip that in at the last minute, then you still have to have privacy by default. So the default settings have to be the most privacy preserving, but they've carved out cookies. So now some people are like, yay, I can go ahead and I can opt people in already automatically to cookies and tracking and browser fingerprinting and everything. I just want to disabuse you of that notion. If you are doing anything, because remember they said technologies that, not cookies, right? So that has to be switched off. So that includes browser font fingerprinting, all the kind of stuff that you do to connect the dots to figure out who somebody is. All of that stuff has to be switched off unless you get opt-in consent. If it is used for profiling, if it's used to identify someone, so you're trying to guess if it's Constantine on the website or not, so you can keep targeting him across the web, or if it's used to, identify or geolocate them. So what does that exception then on cookies mean? Judging by the debates and what they were really trying to do, I think they were really thinking about the things that are strictly necessary, but I think there might be room for analytics to possibly be there. By default, possibly you can make an argument. We have to wait for the guidance on that. But what it all means is that the fact is you're going to have, if you, on the one hand, you'd say, well, I don't have a privacy preference center, so I don't have to worry about turning off anything. That's not going to help you because of the profiling thing that I mentioned earlier. You can't tell people how to turn it on. So you're not even going to be able to get those few opt-ins that you were hoping to get. All that to say, if it's personal information that you're capturing, then, and it's under that broad definition, you got to switch that stuff off and you've got to get people to opt in. So you better find a pretty compelling reason to make them want to do it.
It doesn't differentiate between any kind of technology. Cookie is a technology.
Yeah, and that, exactly. And so that other cookie carve out, a lot of people got excited about. It's not really going to help you on the targeting and the profile. Now, what you could say is privacy preserving analytics. Perhaps you could argue, because there are a lot of privacy preserving analytics tools, they automatically, they generalize the IP address. They only capture what they need, and so they're really just looking at trends. You might be able to argue that it's outside the definition of personal information if it actually meets that irreversible anonymous definition. But again, that remains to be seen. Like they've built in some really problematic ambiguity in there. What I would say is that is different from GDPR and PECR or e-privacy, which is the law we're talking about when we talk about cookies and direct marketing in the EU, is that applies to anonymous data as well. So that's why I would still say the cookie rules and that e-privacy rules are much stricter in the EU, because even if it's anonymous, you're still caught up by it. So that's an important distinction. Here we're talking about personal information when it applies. Although Castle also has some stuff. So
right. So lots to unpack here. Bill 64, we've only scratched the surface in terms of consent and what the impact is going to be on direct marketers. We're going to have a lot more sessions like this, going deeper into different aspects. One of the things that's coming into force this September is the confidentiality incident reporting planning. Every organization has to. Reporting. Yeah. Everybody. They've actually used the phrase confidentiality incident, which means privacy breach or data security breach.
Yeah.
So they've clumped it all together and are calling it confidentiality
They had to
incident
be
reporting.
distinct.
Yes.
You not only have to have a plan in place for this, but you have to have a registry of all incidences that have happened in the
Which
company.
mirrors what's in PIPEDA currently.
Yes.
So
Yes.
And available on demand for inspection as well.
also
difference,
mirroring PIPEDA. Yes. So,
difference
yeah.
being this will be enforced.
And
Well,
there's big teeth and money on it.
yes, and actually, important to note that the CHI is supposed to be getting more budget. And you mentioned, I think, Abigail, there's a
Yes.
VP of
There are
technology.
two things I
Yes.
want to talk about. One, another thing coming in September of this year, September 21st, 2021, September 22nd, 2021, is the person in the highest level of authority is automatically the privacy officer and is accountable for ensuring that all aspects of this law are implemented. So if you as the CEO of your tiny little micro enterprise don't want to be that person, you need to delegate somebody in writing, in whole or in part. That can be somebody internal or external to the organization. So you might want to be looking at privacy as a service, DPO as a service type operations that are operating. There are a number of them out there. Or lawyers who can do it for you. The other piece is the Commission has beefed up. So now they have 2 vice presidents, not just one, responsible for overseeing. So there's the surveillance section and there's the jurisdiction section. Jurisdiction is the privacy rights, DSARs and that kind of stuff. The surveillance section VP has to have the technological expertise and understanding to be able to do their job. So you're not going to be able to pull the wool over their eyes and pretend like, oh, it's all too complicated. You know, we checked the code, it's fine. No, you're actually going to be dealing with a tech geek who understands and can dress you down. So that's a whole second VP. So they've a 2-headed monster now on enforcement, not just one. So
yeah,
lots to do.
Again, lots to unpack. We would love to have you guys back and discuss other aspects of Bill 64 and its impact on marketers. I thank you very much for your input. Should anybody have any questions, you can reach out to Constantine and to Abigail, connect with them on LinkedIn. They're always open to answering questions, as I am.
Getting us to shut up is the hard part.
Yes, exactly.
No, come on. This is what we rely on you for, is your legal interpretation and expertise. Oftentimes, the lawyers are too willing to tell us what we can't do and not really willing to tell us what we can do. And I truly appreciate both. Your style is more what can you do, what practices have to be changed. You have that operationalizing focus on these laws as well. So thank you very much.
Yeah.
And we are 2 minutes over, so I appreciate your time. And we will send a follow-up email with a couple of PDFs. We have one at Newport Thompson where we've actually blended the Bill 64 changes into PPIPS, and we have the new language. So I'll send everybody that PDF, as well as the article, Abigail, you referred to that you wrote.
Yeah, and I put something in the chat. It's the Bill 64 portal that the CHI has. It's only available in French. If you are in the public sector or you have clients in the public sector and you are curious about that, they do have they have their own version of a consolidation of the public sector and of the private sector law, but again, only in French. But at a minimum, it gives you something you can sink your teeth into. Because I think you only did private sector, right, for yours?
I actually did both private sector and public body.
Oh, great.
Yep.
Okay.
Yeah. So I have them as separate PDFs. So
yeah.
If anybody's interested in those, please let me know and we can email that to you in a heartbeat. All right.
Great. Thank you again.
Thank you. A
Bye,
pleasure
everyone.
as always.
Thank you.
Thanks. Bye-bye.